Senator Whitehouse.
Thank you, Chairman. Professor Frost, you distinguish between the adjudicative and the administrative function within the judicial branch. That has constitutional relevance to our ability to legislate?
Yes, I think that's a very important distinction.
Because we have no business interfering in the court's decision-making on matters before it, but as to the administration of justice, we do have the authority to pass laws, correct?
Yes, the Constitution intended Congress to play that role over judicial administration and not
In
interfere with.
fact, Canon 4 of the Code of Conduct encourages judges to testify in legislative bodies regarding the administration of justice. And that would not be there if it were not appropriate for Congress to legislate regarding the administration of justice, would it?
Agreed.
Moreover, you mentioned the Ethics in Government Act, the Ethics Reform Act, and the recusal statute. Those are all laws passed by Congress?
Yes.
And they all apply to the court?
Yes.
Indeed, in some cases, using the word justices specifically, which is the term that applies to Supreme Court justices only, correct?
Yes.
And has the application of those statutes to the Supreme Court ever been challenged by the court itself in the years in which they've been in place, to your knowledge?
Not to my knowledge.
Judge Fogel, you were at the Judicial Conference for many years. You've had to have the role that the Judicial Conference was given by statute, by Congress, to administer these laws. In the context of administering these laws, particularly under the supervision of the Chief Justice, were you ever told that these laws were unconstitutional or that the Judicial Conference or the Financial Disclosure Committee should not enforce them?
No, Senator. The justices complied, as did all of the other federal justices, with the disclosure requirements, or at least they made an effort to.
And in fact, one of the rules, part of the law, is that if there is a financial disclosure violation, then the determination as to whether that violation was willful and is subject to civil penalties actually gets referred to the Attorney General for determination.
That's correct. What the committee does is it looks at the non-disclosure or the incomplete disclosure. It determines whether it's something that could be remedied. Usually the way the committee functions is remedial. They try to get the filer to comply with the disclosure requirements. But if there's a willful failure, then the committee has the authority to make that referral. And
it does so based on a determination that there's reasonable cause for someone to believe that this might have been a willful violation.
That's correct.
And then the willfulness determination gets made by the Attorney General.
That is correct, but I have to
say—
say—
There are civil fines that are potentially imposed if
Yes, sir.
Okay,
that's
go
correct.
ahead, finish what you want to say.
What I was going to say was that the committee tries very hard with the filer to make sure that every effort is made to get a proper filing. So,
in fact, it's okay for a judge, in fact, it's even encouraged for judges and justices to bring concerns about financial disclosure to the committee for a confidential opinion saying, here's what you got to do.
That's correct.
And Justice Thomas did not do that with respect to these filings.
I don't want to comment on Justice Thomas, but normally the committee is there to assist with questions like that.
So has the Judicial Conference, again under the supervision of the Chief Justice of the United States, ever suggested that it was unconstitutional for Congress to require that these forms be filled out, that if there are omissions in the forms, that be referred to the Attorney General, and that a civil fine could be imposed on a justice for failure to file? Has that ever been raised in your conversations?
Not to my knowledge, sir. No.
Well, that's, I think, a little bit telling. I appreciate that. Mr. Payne, are you familiar with the concept of regulatory capture?
Yes.
Sometimes called agency capture.
Yes.
Fairly considerable literature about it in administrative law and economics.
Yes.
So I'll ask you a hypothetical. Let's just say hypothetically that there were an organized effort to capture, in the meaning of regulatory and agency capture, to capture the court in such a way that it was beholden to and ruled in favor of big special interests. That's the hypothetical. Here's the question. If that hypothetical were true, would any ethics concerns be raised by justices consorting with individuals or associating with groups involved in that capture scheme?
Yes, in that hypothetical, there could be potential conflicts of interest if someone was engaged in trying to influence the court and members of the court were engaging in activities with them.
Thank you. My time has expired.
Thanks, Senator Whitehouse. Senator Gray.